Swayam Prabha. Digital India. Educated India.
Hello, welcome to this next module on standard essential patents and FRAND terms and their various issues emerging out of this in the antitrust regulation of European Union. So, in the earlier modules, we have discussed the various safe harbor provisions laid by this TTBER guidelines for the IP licensing agreements, where the licensee as well as licensor can get a safe place where that will be free from the antitrust issues as laid down in the article 101 or article 102. So, as we know so far, so in a technical setup, in a technology transfer agreement, there may be one or more IP involved. It may be in the form of the patents, designs or software copyrights, etc. But the case becomes difficult when the patent is a very essential patent. Essential patent in terms means it is very necessary to define a technical standard. For example, these days all of us are using the smartphones which have like 4G, 5G networks is also coming. So, earlier it was 3G, 2G, 3G, now it has 4G. So, these are a kind of standard like the wireless networks or the DVD format which we all have used at some point of time. So, these are known as the technical standard which all the operator or the player in that segment use in order to be compatible for the users in different devices or in different fields of use. So, there are smartphones, there are smart homes and all these things are coming as the internet of IoT has been developing day by day. So, with this emergence of the technology the industry standards are being set. So, when a patent covers a industrial standard or a particular standard relevant for any technology and it is a major clause in an technology licensing agreement, the case becomes somewhat different in comparison to the other IP licensing agreements. So, before going into the standard essential patents and the FRAND terms, let us little bit discuss about what are standards and how these standard essential patents are being defined. So, technically a technical standard is defined as a document established by the consensus and approved by a recognized body that provides for common and repeated use, then rules, guidelines and characteristics of the various activities of the results and aimed at achievement of a optimum degree of order in a given context. So, there are various standard setting organizations, for example, this ISO, that is which stands for International Organization for Standardization, or ETSI, the European Telecommunication Standards Institute, IEEE. So, there are various standard setting organization that gives a particular technology or that defines a particular technology to be a standard, and these standards are basically very important in terms of for the interoperability of a particular technique or an invention. So, the major commonly used examples for these technical standards include this GSM technology, the 3G technology, 4G technology, then there is DECT technology, smart cards, wireless, Wi-Fi, MPEG formats, DSL, all this, you name all the latest technologies. So, that has quite become a standard in the current day of use. So, these are the standards set by the various technical institutions. So, not only one technical institute sets a standard, it is basically a work of more than one, in many cases it is the work of more than one technical institute which develop various techniques, and that is further given the definition of a standard because of their importance in the relevant area of use. So once the standard has been defined, the technology is the new standard for using in the field of use. But when there is a patent which is for that technology, then the patent is known as the standard essential patents. So basically, a patent that protects the technology essential to a standard is called as standard essential patents, or popularly known as the SEP. So basically, the patent holders contribute the technology for developing standard within the standard developing organization, and once the standard is established, the holder gives the standard patents to the standard setting organization, and in terms they agree to license those technology to all those potential users who want to use them on a what we call as the FRAND terms, on a term which is reasonably favorable to both the parties, or which is known as the fair, reasonable and non-discriminatory terms. And so, once the technology has been set, now the technology is named as the essential technology or the standard essential patent, and by virtue of that, the holder of that right is ready to give this technology to the potential users on the basis of the FRAND terms. So, the FRAND terms basically should be economically favorable for both the parties, and so that it will further help to innovate in the direction, and also there will be a fair use and fair competition in the market. But however, the situation is not so simple as it appears. So, basically the technology users accuse the SEP holders for charging excessive licensing fees based on the weak patent portfolios, and also the continuous like threats coming from the SEP holders to the technology users for the infringement of their technology. And oppositely, the SEP holders claim that the technology users want a free ride on their innovation, and they consciously infringe the intellectual property rights of them without engaging in the good faith licensing negotiation. So, the issue is from both the sides, because the ICP holder has a lot more valuable asset to him. So, it tries to assert its monopolistic power by charging a high licensing fees, and also if someone does not agree with that licensing fees, it may get threatened by the litigation charges. And simultaneously the technology users sometimes also like use the technology without the permission. If the licensing negotiation fails, they start using the technology without the permission, and that may result into a litigation. So, these are the two main issues coming from both the parties. So, let us see how the European Commission deals into this kind of issues. And like when such a situation arises, then the like this standard itself becomes a barrier to the entry of new technology, and also controls the service market or the product market in which the standard applies. And in that way, it kindly leads to an anti-competitive behavior among the parties in the market. And like there are many things like which is known as the holding up or patent thickets, or patent like holding up and patent thickets, which may arise and which may stop the development of the new technology and effective access to the standards. So, in order to avoid all these kind of hassles, generally the FRAND terms has been defined. So, basically the FRAND commitments are designed to ensure that the essential technology protected through these standard essential patents should be accessible to all the users on a basis of fair, reasonable and non-discriminatory terms and conditions. However, the FRAND commitments can prevent the IPR holders from making the implementation of the standard difficult by refusing the licensing request or charging unfair fees or maybe the excessive fees. And sometimes what happens, they try to license the SEP along with the non SEPs, means those technologies which are non essential or non essential patents relevant to that. For example, in the smartphones like this Wi-Fi, 4G, 3G are known as the are a part of these standard essential patents, but sometimes the swiping activities in the screen or the resolution pattern or the design, all these are non SEPs. So, when there is a licensing negotiation, they try to bundle up the IP rights, and that also may lead to a kind of that may lead to a kind of disagreement between the parties, and that may lead to the failure of the agreement and further give rise to the anti-competitive behaviors in the market. So, as I was telling, this is also known as the portfolio licensing, means these SEP holders are generally holders of a number of patents. So, they at a time try to license their technology together. So, they force the potential licensee to take the license of the entire SEP portfolio, and where like the licensor may think that all these are not essential for its technology development process or product development process. So, it is not required for him to get license to for all this thing, and that is the main reason of the dispute in many of the cases. So far in the European Union, there are many cases regarding this standard essential patents and the FRAND terms. Notably, the latest, the Huawei versus ZTE, the Samsung and the Motorola decisions are the major landmark decisions which has shaped the European economic area with regard to the antitrust issues arising out of the standard essential patents. So, in the latest decision of this Huawei case, the European Court of Justice has confirmed that the potential licensee has the right to challenge in parallel to the negotiation relating to the grant of a license the validity of those patents and or to contest the essential standards or their actual use, or reserve the rights to do so in the future. So, it does not mean that once the standard essential, once the patent holder has this SEP in his hand, he should not like he is immune from all the aspects of the competition law, and the licensee may challenge the negotiation or the grant of the license deals, and this has been clarified. And the court also has clarified that the exercise of such right cannot be interpreted as a sign of unwillingness. So, we will discuss all these cases in detail in the later part. And like this Samsung versus Motorola and Samsung versus Apple and Motorola versus Apple, which both these cases has been decided during the same time, and the commission reached the same conclusion in the in those cases, and found that the Motorola's restrictions of Apple's ability to challenge the validity of its patent was capable of having a number of anti-competitive effect. Let us go into detail of this thing. So, in due courses of these cases, the court has also given certain obligations that the SEP holder must follow to avoid its action for a prohibitory injunction. So, the SEP holder must give notice or otherwise consult within the with the alleged infringer prior to initiating any such litigation, and it should alert the alleged infringer of the infringing complaint about by the designating the SEP and specifying the way by which the party is infringing the technology in question. So, coming to the famous case of Samsung versus Apple. So, basically the Samsung has many standard essential patents related to various mobile technologies, and particularly the technology in question in this case was the ETS the 3G UMTS standards, which is a key industrial standard for the mobile and the wireless communication, and this technology has given the status of a standard essential patent. So, in April 2011, the Samsung started to seek injunction against the Apple on the basis of its standard essential patent on this 3G technology. So, while the investigation by the commission, so the commission came to like commission has the question in place that whether like seeking injunction by Samsung, whether the Samsung has failed to honor the irrevocable commitment which he has given to the ETSI, the standard setting organization, European Telecommunication Standard Setting Organization, whether the Samsung has failed in keeping their commitment to, like commitment of providing the technology on a FRAND term basis, and whether it is a violation of the against the article 102 or the abuse of the dominant position as per the Treaty of Functioning of European Union. So, in December 2012, the commission informed Samsung of its preliminary view that that it considered Apple a willing licensee on FRAND terms for the Samsung's SEP, and alleged that against this background, though seeking injunction against the Apple and Apple on the Apple is a kind of abuse of dominant position and is a breach of the article. So, so because Samsung has already committed when the technology is being given as the status of the standard essential patent, the Samsung has committed to the standard setting organization that it will provide the technology on a FRAND terms basis, and Apple. So, in this case Apple was willing to take the license on a fair and reasonable terms. It is a separate issue that their negotiation does not materialize, but anyway, since Apple was willing to take the technology on a certain conditions, so to deny Apple giving license is a kind of abuse of dominant position. So, to address the commission's concern, Samsung has committed not to seek injunction against this Apple company for 5 years in European Economic Area and in the present or the future, and that relates to technologies implemented in the smartphones and smartphones as well as in the tablets, and not only against Apple or any other company that agrees to a particular framework of the licensing for the relevant standard essential patents. And it also like provided a condition that the licensing framework should be provided for a negotiation period of up to 12 months, means a negotiation can be carried out for a period of 12 months, and if no agreement is reached, a third party determination of the FRAND terms by the court or by any other party which the two parties choose, or by an arbitrator if both the parties agrees on this. So, now as the court has tried to settle the dispute by giving them a fair reasonable amount or fair time to reach a consensus for the licensing agreement, and in case there is no consensus between the two parties, so a third party can decide can decide what will be a favorable licensing term and condition for this kind of licensing agreement. And further, an independent monitoring trustee will be advised by the commission to oversee the proper implementation in the commitments. So, this is one of this landmark decision in the history of the European Union, where the court tried to achieve a settlement between the parties, either by the parties themselves or even through the mediation of a third party. Similarly, in a similar case going on in the same time as when the Samsung versus Apple was going on, Motorola versus Apple. So, in this case the European Commission found that the Motorola was seeking an injunction and also trying to enforce the injunction against the Apple before the Mannheim court of Mannheim district court of and like German another district court of the German, basically on the same as a standard essential patent related to a smartphone technology. And this standard essential patent in question was related to GPRS standard, or the part of otherwise known as the GSM standard, which is a key industry standard for the mobile and the wireless network. So, here like in all the cases of abuse of dominant position, the court tried to find out what is a relevant market and what is a geographical market. So, in this case the court tried to identify the relevant market as the market for the licensing of the technology as specified by the GPRS standard, the technical specification on which the Motorola's QDAC GPRS standard essential patent was read. And the market for the downstream products, basically the smartphones on which the GPRS standard compliant products are sold, was not considered relevant in this case, because the turnover achieved with the licensing of this GPRS and SEP technology was different from the turnover achieved with the GPRS standard compliant products. So, basically only the licensing of this GPRS technology was considered to be the relevant market in this case, and the geographical market was the European economic area. So, after deciding this market, now the second question was to find out whether Motorola hold a dominant position in the market or not. So, for this, so both the demand side and the supply side substitutability was analyzed, and finally the European Commission concluded that Motorola does not have any substitute in the European economic area, and Motorola holds 100% share in the market, and it is the major it is the dominant player in the market for this technology, for this GPRS standard. So, again while considering this, there are like the court considered two important factors while assessing the dominant position. First, the indispensability of the GPRS standard on which Motorola's QDAC GPRS SEP was read for manufacturing standard compliant product. Second, the industry lock-in to the standards, means the court tried to find out whether there is any substitutable technology available in the European economic area for this QDAC GPRS standard essential patent or not. And it found that there is no substitution, because the product was so popular in the market and the people are so used to this kind of technology, and it was gaining a popular demand. So, it was really indispensable or unsubstitutable in the market. And second, all the industry are all the industry which are operating in that field was trying to use or trying to adopt the technology. So, basically the industry had locked into the standard. So, both the factors were satisfied, and for that reason the court also decided that Motorola is holding a dominant position in this particular GPRS standard. So, after this question, once the dominance position is established, now the second question whether there is a abuse of dominant position is not. So, after it has been said that Motorola is having a dominant position in this GPRS standard market, now the commission came to the conclusion that seeking an enforcement of an injunction by a patent holder including SEP holder is generally a legitimate course of action, because in like the other normal IPR, as an holder of the intellectual property right, one has the very right to seek an injunction against any unwillful or any user which has not taken permission from the IP intellectual property owner. So, in this case also the SEP holder can also seek the enforcement or injunction enforcement of the injunction as a legitimate course of action. But when the certain FRAND terms are associated with this SEP, then the situation becomes a little bit different from the normal cases. And in this case particularly, the Apple's willingness to enter into a contract licensing agreement with the Motorola, where Apple has already allowed Motorola to set the royalties according to its equitable discretion, means there was already talks going on where Apple has offered Motorola's discretion for setting the royalty terms. So, the situation is again becomes critical in lieu of that evidence. And further the Motorola was allowed to review the amount of the FRAND royalties, whereby both Motorola and Apple could submit their own evaluations, calculations and reasoning for the consideration of the competent court. So, According to the Commission, the assessment of Motorola's conduct as an abuse of dominant position strikes a fair balance between the three interest at issues. First, the rights linked with the intellectual property, the rights the rights of access to the tribunal, and the freedom to conduct business. So, in this case no fine was imposed on Motorola. However, again the court tried to strike a balance between these two parties and try to settle down with a favorable licensing condition between the two parties. So, basically these two antitrust decisions of Motorola as well as the Samsung provides a path for patent peace for the so called smart wars regarding the smart telephones. So, in these both the cases, the Commission clarified that in the standardization context where the SEP holders have committed to license their standard essential patents and to license their standard essential patents on fair, reasonable and non-discriminatory terms, it is anti-competitive to seek to exclude the competitors from the market by seeking injunctions on the basis of the SEPs. So, if the licensee is willing to take a license on the FRAND terms. Again, in these circumstances, the seeking of injunction can distort the licensing negotiation and lead to unfair licensing terms with a negative impact on the consumer choices as well as the prices. Since in both the cases Apple was willing to enter into the licensing negotiation and it has offered the best FRAND terms possible from its end. So, Apple has initiated something, but since it did not materialize, that does not mean that it is infringing its right. So, both the parties should try to achieve a kind of harmonization in the selection of the royalties or other conditions as laid down. So, but merely seeking or enforcing an injunction over the SEP is not a solution, and that may lead to anti-competitive effect in the market and also provide hamper the innovation in the market and limit the consumer choice. But this Motorola and the Apple judgment was a kind of the recent decisions where the court has tried to favor the licensee or tried to achieve a harmonious situation between the two parties. But in the earlier judgments, it was it has more favorable approach to the patent owners. For example, in the Orange Book standard case, the German Federal Court of Justice has adopted a more favorable approach for the patent owners. So, there the court stated that in order to avoid an injunction, the license seeker should not should meet two specific conditions which is not mentioned by the EC's decision. First, making an unconditional binding offer for the conclusion of a license that the patent owner cannot refuse without being in breach of its obligation. Means the licensor would have to provide the best offer to the licensee to get the technology in place, and the licensing offer should be such that the patent owner should not refuse it. And secondly, satisfying in advance the obligations ensuring from the license agreement that is being concluded. So, this criteria has been further specified by the German lower courts, which is generally very strict conditions for the license seekers. So, all the burdens were on the license seeker rather than the patent owners. So, this is the earlier cases, but with the Samsung and the Motorola, the burden was quite on the patent owners. So, this is the gradual shift as the standards are developing in the European or in the global market. There is a gradual shift in the approach of the court also, as we are seeing in those cases. So, also in the latest Huawei case also, the Huawei versus ZTE, Samsung as well as the Motorola cases, both the European Court of Justice and the European Commission has clarified the limits of the SEP holder's right to seek the injunction against a prospective licensee who has allegedly infringed the patents. So, these three cases were like the landmark decisions where the court has given various guidelines and always also they clarified the limits of the SEP right holders. So, in the Huawei case, both of them were the Chinese manufacturer of the smartphones. So, the Huawei has a patent on the LTE standards, which is also one of these important standard for the mobile communication, and this patent was conferred the status of the standard essential patent. ZTE company, one of the leading Chinese leading Chinese company. So, he tried to enter into a cross licensing negotiation with Huawei and on the basis of the FRAND terms. But however, the licensing agreement did not materialize, and this technology in question was for synchronizing signals sent out by the transmitter to a receiver in the mobile communication environment, which is basically by describing how to transform certain signals in a particular efficient way by defining the so called Fourier frequency coefficient that was centrally symmetric. So, the technology was all about, it is a kind of, it is related to something LTE technology, and so, the ZTE wanted to have cross licensing, means ZTE is also ZTE also had certain patents in place, which he thought that would be relevant for Huawei for implementation of its production, and that is why Huawei ZTE tried to have a cross licensing negotiation with the Huawei. So, as the licensing negotiation did not materialize, so the Huawei tried to enforce an injunction against the ZTE. So, again in this case the main issue raised were whether the injunction against the ZTE like by the owner of this SEP, that is Huawei, is violation of article 102 of Treaty of Functioning of European Union or not. So, the patent in question, that it has the granted patent for that, which was granted filed in 2008 and granted in 2011. So, the negotiation has started in the year 2010, where this ZTE which basically produces the LTE base stations started negotiating with Huawei, and after 6 months of negotiation they could not reach a settlement, or could not the negotiation failed basically, and finally in April 2011 Huawei filed a patent infringement action against the ZTE in the District Court of Germany and filed injunction against the ZTE. So, the District Court of the Germany, the result of a court asked, like basically in this case the District Court asked 5 questions, but out of which only the first question was answered by the European Court of Justice. So, the first question which the District Court asked regarding this case was, does the proprietor of an SEP which informs a standardization body that it is willing to grant any third party licensing on a FRAND terms abuses its dominant market position if it brings an action against action for injunction against any patent infringer, even though the infringer has declared that it is willing to negotiate concerning the license. Means first, as we know, when a patent is declared as a standard essential patent by an standard setting organization, the after this declaration in general the patent owners agree to provide the license to any potential users on the basis of FRAND terms. So, when they have agreed to this clause, so is it valid, or is it a kind of going against that declaration, like whether this kind of seeking an injunction would be against the so called patent infringer is desirable. First, that was the question. Second, the second part of this first question was, is an abuse of the dominant market position to be presumed only where the infringer has submitted to the proprietor of the SEP as an acceptable unconditional offer to conclude a licensing agreement which the patentee cannot refuse without unfairly impeding the infringer or breaching the prohibition of discrimination, and the infringer fulfills its contractual obligations for the act of use of already performed in an anticipation of the license to be granted or not. So, this was just as the question is the whatever the court has asked. So, when when the infringer has already given the proprietor the offer for the licensing agreement, which the which the patentee cannot refuse, only in that condition, after that condition can we ascertain the abuse of dominant position, or when the dominant position will be considered to be abuse of dominant position. So, that was the question, the first question which the district court asked. Second, if the abuse of the second question asked by the district court was, if abuse of a dominant market position is already to be presumed as a consequence of the infringer's willingness to negotiate, does the article 102 lay down any, does the article 102 lay down any particular qualitative or the time requirement test in relation to the willingness to negotiate? Means, is there any timeline defined as in the article 102 where there should be within which the licensing agreement should be negotiated? So, again in particular, can the willingness to negotiate be presumed where the patent infringer has merely stated, like orally, in a general way that it is prepared to enter into the negotiation? Is an oral agreement will be valid in this case or not, or there should be any specific condition that the licensee, the willful, the potential user should give to the licensee to seek or to show its willingness to enter into the license. So, only oral willingness is acceptable, or there should, or whether there should be any written requirement, specification requirement should be there for so that it is willing to enter into the negotiation or not. The third question was, if the submission is an acceptable unconditional offer to the to conclude a licensing agreement, so does article 102 lay down any particular qualitative or time requirement in relation to the offer? So, how long do that offer will be valid or not? And shall the offer must contain all the provisions which are normally included in the licensing agreement in that field of technology in the question. So, whether what should be the provisions laid down in that licensing agreement, and is there will be any particular subject or conditions which should be specified in the agreement, which will show that whether the agreement is valid or not. So, this is the third question which the court has district court has asked. And the fourth one, if the fulfillment of the infringer's obligation arising from the license that is to be granted is a prerequisite of the abuse of dominant market position, then is there any requirement with regard to this act of fulfillment in article 102, or is the infringer particularly required to render an account for the past act, use or pay royalties, like if the user has already used it or whatever the past acts. So, will there be any accountability for that? And there may be any obligation to pay royalties be discharged if necessary by depositing a security. So, will there be any security deposit for entering into that licensing negotiation? So, under which condition it will be considered as an abuse of dominance position? What will be the criteria for or criteria of this licensing negotiation on the part of the licensor as well as the licensee? So, the last question in this relation were, do the conditions under which the abuse of dominant position by the proprietor of an SCP is to be presumed apply also to the action on the ground of the other claims arising from the patent infringement or not. So, these were the 5 questions which the district court asked, and finally, in the European Court of Justice only the first questions were answered. So, the court basically the European Court of Justice, the court defined 2 conditions for the assessment of the abuse of the dominant position when the plaintiff is seeking an injunction, namely first, whether the alleged infringer unconditionally offered to enter into a licensing agreement with the SEP holder with a royalty offer sufficiently high that the patent owner cannot deny the offer or cannot refuse the offer, or where the alleged infringer behaved as if the license has actually been taken, that is rendered an account of its act of use of the patent and paid respective royalties. So, basically the court placed the burden of fulfilling those kind of conditions on the defendant. So, here the court basically little bit deviated from the earlier judgment of Samsung and the Motorola, and the burden of action were like on the defendant, but like again it tried to settle down the matter where both the parties can further negotiate the agreement and come to mutually beneficial licensing negotiation. So, even though a middle path was taken by the court in this case, but there were few questions which remained unanswered. First, it was unclear that under which circumstances the ownership of the SEP confers the dominance. Second, while voluntary portfolio licensing is not illegal, and SEP holders you have to take either all the technology or not or no technology. Like for example, in this case in the Huawei versus ZTE, this LTE technology, there was nearly 450 LTE related technologies that the Huawei was offering to ZTE, and there were nearly 40 SEP holders for that. So, you may imagine to enter into a licensing agreement for these 450 technologies with 40 holders is not a matter of it's not so easy to reach into a settlement, reach into a mutually beneficial agreement in such a technology. And again, in those cases, whether to license the whole patent portfolio is required. Like if the ZTE does not want to take the license for the whole whole 450 standard essential patent, why it should give money on account of all those patents. So, in general that becomes the situation where not only one SEP is in question. So, the SEP owner try to give or bundle the number of SEPs which he is having to, and try to license all of them to the potential user. So, in those cases the dispute arises. Coming back to, so the third question which remained unanswered was, although the European Commission has yet to scrutinize the refusal to license and its component level, it is not clear if such refusal is contrary to the FRAND commitment and also to the article 102 of this Treaty of Functioning of European Union, as it may amount to a discriminatory refusal to deal, or maybe because of the excessive royalties. So, who decides what is a FRAND terms? So, a fair, reasonable and non-discriminatory term may be different in the eyes of the licensee or the licensor. Then who will be the best person if there is no agreement on the condition FRAND terms, then who will decide what is a FRAND term, and under will there be any defined time period under which the FRAND terms should be defined or negotiated. So, these are the questions which is still unresolved. And the fourth one, there is no official view whether the SEP holders transfer of the subset of the SEP to a patent assertion entity or the PAE may breach the EU competition law. So, the patent pooling, patent thickets and patent portfolio licensing, all this issue arises out of this SEP context. So, to reach a FRAND term, like it's very easy or very simple. It appears like the SEP holder must agree to a FRAND must agree to FRAND terms and condition, but to reach the FRAND terms and condition is very difficult given the situation. The licensee tries to negotiate for all the SEPs or tries to associate the non-SEPs with the SEP, or the vice versa situation may arise where the licensor is trying to just free ride the technology and use it for its benefit. So, so these like all these have led to the recent debates in the licensing and the SEP technologies. So, recently in the month of June 2019, there are guidelines has been set by the for the use of 5G technologies and other IoT SEPs. So, similarly in April 2016, the communication on the standardization priority for the digital single market, the Commission identified 3 main areas where the SEP licensing environment could be improved. So, there should be opaque information on the SEP exposure, like what is SEP, under what conditions the SEP is regarded as a standard or a technical standard. Then unclear valuation of the patented technologies, reading on the standards and definition of the FRAND, and the risk of uncertainty in the enforcement of the SEP. So, also, in addition to these 3 criteria, the role of open source communities in the development of the standards are also being taken as a major area where the where more work is required so that the SEP environment can be improved. And if you like in the recent guidelines, they give certain emphasis on what principal terms are included in a typical patent SEP license. So, in a typical patent SEP patent license, so the details should cover the standards covered and therefore, the SEP is licensed, product and services and field of use, under which field the SEP can be used, what territory should be covered, the term of the license should be dealt, the royalties, payments and auditing rights to whom it would be given, that should be clear in the licensing agreement. The dispute resolution clauses, which may also cover the future licensing agreements if agreed, and if both the parties agreed, then the inclusion of the non-standard essential patents in the licensing agreement should also be covered in the SEP patent license. And like one of the main disputes in the like how to set the royalty in the FRAND terms or SEP license. So, basically there is no single rule by which a royalty can be decided. So, there are various common royalty calculation terms depending on the SEP's like owners practices and circumstances in the technology. So, either they are decided per unit cost or a percentage or the selling price of the percentage of the net selling price of the licensed product or service, or a lump sum payment. So, if there is no previously calculated method, so any recent examples they may take and they make in that technology area and may calculate the royalty accordingly. And the calculation might include a cap or a floor, and like as we told, percentage per rate per unit or lump sum cost may adjusted depending on the say total sales volume. And so, like if the question what is a fair and reasonable license is also issued in the latest guideline. So, generally the methods used by the courts can include the like basically they look into the various case laws that has emerged earlier in the similarly situated companies. So, in absence of such examples, the evidences a potential licensee can look into the publicly available market data, and which can provide certain guidance on whether the license offer is a FRAND or not. So, basically those are like the public announcement on the royalties by SEP owning companies and the patent pools, or the information on the royalties and the licensing terms and available court decisions. So, so these are the certain guidelines which has been provided in the latest 5G and IoT like licensing of the SEP related to 5G and IoT. The documents will be shared in the link of this video, and please go through it. That will give you a latest insight into how the guidelines has been given and how it is helping the standard essential patent owners as well as the potential licensing. So this is a very what you say controversial area. So as and the cases are being decided depending on the merits and the jurisdiction. So hope this will few examples would give you a little bit idea, and we will discuss more about it in the later section. And in our next sections we will deal how the competition rules and intellectual property rights interfere in the Indian competition law context. So stay tuned for the next module. Thank you.